All right, let's dive into a story that starts out simply enough. You've got a homeowner, a real concern about wildfire, and a homeowners association. But what begins as a simple safety query spirals into a full-blown legal battle. It's a classic showdown, one man against his HOA, and it all kicked off with a single, pretty shocking phone call. So picture this. You're Randall White, the homeowner. You're excited, you're buying a new home, and you call your insurance company to get it covered. And they just flat out tell you, nope, sorry. The wildfire risk there is just too high for us. I mean, talk about a wake-up call, right? That one conversation, that denial, well, that was the spark that lit the fuse for this entire conflict. So what do you even do in that situation? Your new home is apparently in an uninsurable fire zone. For Mr. White, this wasn't something he could just let go. It was a call to action. And this first part of the story is all about him trying to get some real answers. And if you look at the timeline, his steps make perfect sense. January 2022, he buys the home. Shortly after, he gets that bombshell from the insurance company. So by April, he's doing the logical thing. He calls the local fire department. And hey, great news. By the end of the month, an inspector agrees to come out and do a complimentary assessment. Everything seems to be moving in the right direction. But, well, that's not exactly how it played out. And this is the moment where the story just takes a complete U-turn. That inspection, the very thing Mr. White was counting on to get some clarity, it just stops dead in its tracks. And here it is. This is the piece of evidence at the absolute heart of the whole thing. Just a few days after the inspection was scheduled, Mr. White gets this email from the fire inspector. It basically says an HOA board member, a Mr. Tittle, contacted him and said, hey, you need to go through the management company for this stuff. Now, for Mr. White, this email was the smoking gun. This was proof the HOA was shutting him down. And that really gets us to the core question of this entire case. Was the board member, Mr. Tittle, deliberately interfering and stopping a safety inspection? Or was he just doing his job? Following the rules and telling a government official that any community-wide business has to go through the proper channels? That's what the judge has to figure out. So let's just lay out the two competing stories here. On one side, you have Mr. White holding up this email and saying, see, they stopped it. But on the other side, when the board member, Mr. Tittle, was asked about it in the hearing, his official testimony was that he could not recall sending it. So you've got documented evidence versus a foggy memory, a classic he said he can't remember situation. At this point, Mr. White feels like he's hit a brick wall. He truly believes his HOA is actively blocking a crucial safety assessment. So he decides there's only one path left. He's going to take it to the next level and file a formal complaint with the Arizona Department of Real Estate. But wow, even just getting a hearing proved to be a battle. The official court documents show this whole procedural maze Mr. White had to run. His first attempt was kicked back as deficient. His second try was also rejected, this time because he was apparently citing laws that didn't even exist. It actually took a third attempt before the system finally accepted his complaint and scheduled a hearing. Okay, so before we jump into the hearing itself, we have to talk about a really important legal concept here, the burden of proof. It's a simple idea, but it's absolutely critical. It means that the person who makes the complaint, that's Mr. White, has the job of proving his case. It's not enough to just accuse the HOA. He has to present enough evidence to convince the judge that his story is more likely to be true than the HOA story. Remember that, because it ends up being the whole ballgame. All right, the paperwork is finally in order. A date is on the calendar. Let's step inside the administrative hearing and see how both sides argued their case. The arguments were crystal clear and, as you can see, polar opposites. Mr. White's whole case was that the board acted in bad faith, that they deliberately interfered, and that the May 3rd email was proof. The HOA's lawyers fired right back, saying, hold on a minute, Mr. White is just one homeowner. He has no authority to schedule an inspection for the whole community. Telling the inspector to talk to the management company wasn't interference. It was the correct thing to do. Now, the judge pointed out a major problem with Mr. White's case from the very beginning. Remember how his first few petitions got rejected? Well, the judge noted that even in the final version, the specific laws and statutes Mr. White was claiming the HOA broke were, well, either completely outside the court's power to rule on, or they literally didn't exist. That's a huge foundational crack in your legal argument. So, after listening to all the testimony, reviewing all the evidence, including that key email, the administrative law judge came to a final and legally binding decision. This is it. This is the moment of truth. And here's how the judge broke it all down. These are the key findings that decided the case. First, the judge agreed with the HOA. Mr. White, as an individual, didn't have the authority to schedule that kind of inspection. Second, a small but important detail, the inspection hadn't even started yet when the contact was made. And finally, the big one. The judge found that Mr. White just failed to prove that the HOA actually broke any laws or even their own community rules. He did not, in legal terms, sustain his burden of proof. And with that reasoning, the final verdict came down. In big, bold letters, straight from the official order, the petition was denied. Case closed. After all of that, the frustration, the filings, the hearing, the judge ruled in favor of the homeowners association. So what's the big takeaway from all this? This case really puts a spotlight on the tricky balance every homeowner in an HOA has to deal with. And it leaves us with this really interesting question to think about. When you're trying to do something for the good of the community, for everyone's safety, at what point does your proactive concern cross a line and become you overstepping your authority? It's a fine line to walk.